Morning, everyone, and a warm welcome to today's London Shipping Law Centre YMP event on Bitesize Case Updates 2021 webinar, organized in association with Pump Court, Essex Court Chamber. In case any of you don't know me, I'm Francesca Cappa. I'm chairing the YMP and a shipping lawyer at MFB. Many of you would be already familiar with the London Shipping Law Centre and the YMP, but just for those who aren't, the YMP is a London-based social networking education association founded by Dr. Shanghai Shipyard to support younger members of the maritime industry. The YMP is part of the London Shipping Law Centre, and our aim is to promote cross-sector networking, education, exchange of ideas, and to further professional development. We run events ranging from panel discussion, short talks, on-site visits, and purely social events. We are today very grateful to Pump Court and Essex Court Chamber, and of course, in particular, to Andrew Stevens and Owen Lloyds for organizing today's webinar. For all the challenges that the pandemic has presented, and as much as we all miss in-person events, one of the advantages of going online is that we've been able to reach a much wider and more international audience. And it is excellent to see so many participants signing up, I'm told more than 360. And so, I'd just like to thank you once again for joining us. And now I should hand over to our moderator, Andrew Stevens, who is a barrister at Pump Court, specializing in international arbitration, including energy, shipping, and commodities.
Thanks so much, Francesca. A warm welcome to everybody to this LSLC Young Maritime Professionals webinar, as Francesca has eloquently introduced to you all. We're very lucky to have four junior shipping barristers here today to give you handy bite-size updates on recent and important shipping cases. We're very grateful to our four speakers for preparing their talks, for giving up their time, and for joining us today. So do all please take a moment to register their CVs, which were emailed to you yesterday. We'll be starting off with a presentation by Elliott Cook, who is a member of Pump Court, previously a commercial solicitor. He will be speaking about a case hot off the press from the Court of Appeal that came out on the 18th of November, the Eternal Bliss. He will be followed swiftly by Clementine Makower, who is one of the newest tenants at Pump Court, who will be speaking about a case on the termination of commodities contracts where the goods are off-spec. Then there will be an opportunity for Q&A. So you'll see down the bottom, hopefully, of your Zoom screen, a Q&A function. So do please submit your questions as we go along. After Elliott and Clementine, we will have a quick Q&A for their talks. Then we'll move on to Adam Board, barrister at Essex Court Chambers, who's ranked for shipping and commodities, and my long-time opponent. I had the joy of being against him for a long time on a series of shipbuilding arbitrations, as well as in the commercial court and the Court of Appeal. He'll be speaking about an important decision regarding guarantees, specifically guarantees in support of shipbuilding contracts. And finally, we will have Anna Hoffmann, also from Pump Court, with whom I've had the great pleasure of working, but most importantly, who was junior counsel in the UK Supreme Court case on the prorogation of Parliament. She will be speaking about the Tai Prize and implied indemnities in bills of lading. After Adam and Anna, there will again be Q&A on their two talks, so do please put your questions in the Q&A box, not the chat box, if possible. So like I said, we're very grateful to all of these speakers for giving up their time. Do please check out their CVs sent to you yesterday, and I shall hand straight over to Elliott.
Thank you very much, Andrew, and thank you very much for having me this morning. It's absolutely my pleasure. I'm going to talk to you today in the 10 minutes that I have about the Court of Appeal's recent decision in the Eternal Bliss. And as Andrew mentioned, it's hot off the press having been delivered on the 18th of November of this year. You'll see, I'm going to get straight into it because I haven't got too much time, but what I'm going to cover today is just to set the scene, what is demurrage. I'll then move on to the facts of Eternal Bliss. I'll then briefly describe what the issue that the Court of Appeal, the important legal issue that the Court of Appeal had to decide before moving on to the Court of Appeal's decision and its reasoning. And hopefully I'm not overstating it when I say that this decision is probably one of the more significant and important decisions on demurrage that's been handed down for quite some time, arguably since the 1920s. So it is an important decision. It's also a very digestible decision. So if you do want to go away and read it, or if you haven't already, then I certainly encourage you to do so. I'm going to start off just to remind everybody what demurrage is, at least in a nutshell. And the Court of Appeal made it very clear, and it was agreed by all parties, that what demurrage is liquidated damages payable by the charterers to the owners for breach of the charterer's obligation to either load or unload the cargo within the contractually stipulated period of time. And that contractually stipulated period of time is often called lay time or lay days. So basically, it's essentially payments, liquidated damages paid by the charterers to the owners for keeping the vessel at either the loading port or the discharge port for longer than it should be there. And so liquidated damages for the detention or the delay to the vessel and in breach of that lay time obligation. But the question, the fundamental question is, well, what losses, what types of losses does demurrage liquidate? Does it liquidate all types of losses, or does it only liquidate one or some types of losses? And that's kind of the question that was asked. Just to go through the facts of this case, this was an application under Section 45 of the Arbitration Act for a determination of a preliminary point of law. So actually, a lot of these facts were assumed facts that were agreed by the parties in order to get this legal question answered. So there may be, I'm not sure there will be at the moment anymore, but there may be an arbitration about it where these facts are actually in dispute. But for present purposes, there was a contract of affreightment between K-Line as owner and Primmans as charterer. It was on the Norgrain 1973 form as amended. That form contains a very standard demurrage clause, which doesn't actually really say what types of losses are covered or not by demurrage. It just says, in a nutshell, demurrage is payable at X rate. So not much is said by that clause, but that's what the parties were dealing on. The Eternal Bliss, the vessel in question, was nominated for a voyage in June 2015. It was carrying about 70,000 metric tons of soya beans, and it was going from Brazil to China. It arrived at the Chinese port, it tendered its notice of readiness, and then it sat there for about 31 days. And the reason why it sat there was because of port congestion, and there was also a lack of storage space ashore, which meant that it had to wait there in order to be allowed in. So it was agreed for the purposes of the application that the charterers were in breach of their lay time obligation. They were in breach of unloading the cargo within the contractually stipulated period of time. Now, while the vessel was sat there, the delay caused the cargo, the soya beans, to deteriorate. There were significant portions of the cargo that exhibited molding and caking. And it was agreed, again, for the purposes of this application, that it was the delay that caused that deterioration. So we have breach and we have causation, all assumed. Importantly, though, the only breach was breach of the lay time obligation, breach of the charterer's duty to unload the cargo within the contractually stipulated lay time. What happened is that the cargo receivers, completely different party, the cargo receivers sued K-Line, the owners, for the deterioration of that cargo. They made legal claims against the owners. The owners settled those legal claims for $1.1 million US. So they paid out $1.1 million to the cargo receivers in settlement of their legal claims. Now, the owners wanted to recover their settlement payout from the charterers, saying it was a loss caused by their breach of the laytime obligation, caused by the delay. It was a loss. But they didn't want to claim it as a part of demurrage. They wanted to claim demurrage as well, and they also wanted to recover as unliquidated damages this settlement payout. So they wanted both of those things. And they came to the court wanting to know if that was allowed. And the charterers, of course, said that wasn't allowed. The charterers said, no, you've only got a breach of our laytime obligation. Your only remedy is demurrage. You can't get anything else if that's the only breach that you've got. And that essentially was the issue. Were the owners allowed to recover as unliquidated damages, in addition to demurrage, this $1.1 million payout? And they claimed it was a different kind of loss. Demurrage only really covers one kind of loss, which is loss of use of the vessel as a profit-earning chattel. Loss of use being essentially that the owners couldn't then make money with the vessel on further voyages and further charter parties because it was detained for longer than it should be. That's the only kind of loss in the owner's argument that was covered by demurrage. And then if there was any other kind of loss, such as the settlement payout, then that could be claimed outside demurrage as unliquidated damages. Charterers disagreed, and that's why it set itself up for this preliminary determination on a point of law. What charterers argued, and was, I think it's fair to say, was the orthodoxy, going back to a decision by Justice Potter in 1991 called the Bond or the Bondi. I'm not sure how to pronounce it, but the Bond or the Bondi. What charterers argued was, no, when you've only got a breach of the laytime obligation, your exclusive remedy is demurrage. That's it. If you want to claim unliquidated damages, in addition to demurrage, you have to prove a separate kind of loss. A separate breach of the charter party. You have to come up with two breaches, not just the one. So that was the issue. That was the issue that faced the Court of Appeal, and it was the issue that faced the first instance judge, Andrew Baker Jay. I'm going to go through his reasoning and decision very briefly because it sets us up well for the Court of Appeal decision. Andrew Baker Jay agreed with the owners. He held that on the proper interpretation of this demurrage clause, and again, the demurrage clause didn't say much, but on the proper interpretation of this demurrage clause, the parties only intended it to liquidate essentially one type of loss of use. Some other associated types of loss, but I'll put them to one side for now. It was only intended to liquidate loss of use. That the owners were free to claim unliquidated damages in addition to demurrage, even though there was only one breach, that being the breach of the laytime obligation. Andrew Baker Jay identified it as a question of contractual interpretation. That's the issue, essentially the legal issue that he was dealing with, and he had to deal with it on the basis of what commercial parties would consider demurrage to cover. And he reasoned that commercial parties would consider demurrage only to have liquidated the one type of loss of use. That's what commercial parties would believe or intend demurrage to cover. And that's largely because, I think it's fair to say, case analysis aside, he went through all the cases, he went through all the textbooks, I won't bore you with that. But essentially what he said was that when fixing the demurrage rate, commercial parties usually do so by reference to the going market rate for that vessel. And that's what it's really meant to compensate. That's what really demurrage is meant to compensate, the loss of use by reference to the market rate. He also, however, gave permission to appeal. So we end up in the Court of Appeal, which was handed down less than 2 weeks ago. And I'll put you out of your misery. The Court of Appeal came to the opposite conclusion to Andrew Baker Jay. They held, or it held, that demurrage, in the absence of a contrary intention by the parties, and I'll come back to that, in the absence of a contrary intention, demurrage covers all types of losses arising from a charterer's breach to either load or unload within the contractually stipulated lay time. So if that's the only breach you've got, then the only remedy the owners have is demurrage. They can't claim anything else. If they want unliquidated damages in addition to demurrage, then they have to prove at least one other separate breach of the contract. Now, what I find interesting, if you compare the two decisions, is that at their foundations, there's a lot of similarities. Number one, they both agreed that it was a question of contractual interpretation. Now, that wasn't controversial, but it can get lost amongst all the kind of discussion about what demurrage is going back to the 18th century, et cetera, et cetera. Fundamentally, it was a question of what these parties intended by the demurrage clause that they agreed. So it was a question of contractual interpretation. Both courts said that. Both judgments also took the approach of what objectively commercial parties would agree, taking into account commercial considerations. It's from there that the two judgments differ. And the reason they differ is because they have some different ideas about what commercial parties might want. For the Court of Appeal, fundamentally, it decided that it would be very unlikely for commercial parties to forego all the well-known benefits and advantages that liquidated damages clauses have. Liquidated damage clauses are well known. It was well known for many years, at least in a construction context, that liquidated damages clauses have all these advantages. Their finality, their predictability of parties' future financial risks and liabilities. And they also have the advantage of getting rid of all those very hard to prove aspects of breach of contract. So causation, mitigation, remoteness, those kinds of things. And it's much more likely that when the parties agree to demurrage, they want to include all those advantages of finality, predictability, and certainty into that demurrage clause. And the Court of Appeal did make what I think is a funny comment. They said construction cases do not help. But then they also used construction cases, or used the reasoning, they didn't cite any construction cases, but used the reasoning in construction cases to feed into why they said it was unlikely that liquidated damages, that demurrage was intended to only cover some types of losses. So that was their first reason. It tied in with their second reason, which was, well, where do you draw the dividing line between types of losses that are covered and types of losses that aren't covered? It's much easier and better and more certain just to say they cover all types of losses. But more fundamentally, I think when it compares to Andrew Baker, Jay, the Court of Appeal did not agree that when parties negotiate and agree demurrage rates, all they have in mind is loss of use of the vessel. It's a much more complicated negotiation than that. And that might be one factor, but it's certainly not the only factor. And it's not for the court to interfere with the parties' allocation of risk. So the court thought it was more likely that these parties intended for their allocation of risks to be respected and for the court to come up with a default presumption that all losses arising from a breach of the lay time obligation were covered exclusively by the demurrage regime. And then lastly, they said, look, this has stood the time for 30 years now. The Bondi, Justice Potter's decision in the Bondi essentially came to the same conclusion that we did, albeit with less reasoning. And it would seem that the market hasn't really been fussed by Justice Potter's decision. It's gone on for 30 years. There's been no widespread upset. Let's just keep it like that. And if the parties want to change that, if the parties want to depart from the general rule and divvy up the losses so that demurrage only covers some of them, well, then they're free to do that. And they can say so expressly in their contract. So that's where we've ended up with the Court of Appeal, essentially restoring the position to what it was after Justice Potter's decision in the bond. They did refuse permission to appeal to the Supreme Court. However, I would assume, if I were a betting man, which I'm not, but if I were, I would assume that the owners might be petitioning the Supreme Court if they haven't already. So I think this is a watch this space kind of moment. That's all I have to say about the Eternal Bliss. Thank you very much for listening. I'm going to hand it over now to Clementine, who's going to talk about Galtrade and BP Oil International and off-spec commodities. So thank you very much, and I'll pass you over.
Thanks, Elliott, and good morning, everyone. So, as Elliott said, I'm going to talk about Galtrade Ltd and BP Oil International Ltd, which is a decision of the High Court, which was handed down in July this year. And in this case, it was held that the term in a contract for the sale of fuel oil, which required the oil to comply with specified minimum or maximum tolerances for certain pollutants or properties, was not a condition of the contract. And this means that a buyer who receives fuel oil that doesn't comply with the specifications is not necessarily entitled to reject the oil or to terminate the contract. So this decision has important implications for two things that I'd like to talk about today. Firstly, for how contracts are drafted, parties that want to allow for a right to reject if the commodity does not comply with the specification should make that clear in the contract. And secondly, it has important implications for the circumstances in which a buyer might be entitled to reject goods that don't conform with the contract. So in this short talk, what I want to do is to set out the facts of the case quite briefly, and then provide a little more detail on those two areas. So turning firstly to the facts of this case, what happened was BP, who was the defendant, had agreed to sell 4 parcels of fuel oil to Galtrade, and Galtrade was another company also involved in oil trading. The contract used was BP's general terms and conditions for the sale of crude oil, and those terms are quite widely used in the industry, as I'm sure many of you might know. And this contract had a section called guarantees, and the guarantees section set out the specifications for the fuel oil. And that included, among other things, but what was particularly important in this case, was a maximum value for the amount of sulfur that the oil was permitted to contain. And sulfur is a pollutant in fuel oil, and the more sulfur, the less valuable the fuel oil is in general. And so I said that there were 4 parcels of fuel oil involved. This case really revolved around the third one. The third parcel did not comply with the maximum and minimum values in the contract, in particular because the sulfur content was too high. So Galtrade then rejected the fuel oil. And I just want to provide some very brief background on the relevant law, which I'm sure you'll all be very familiar with. But before this decision, it was widely believed in the industry that the requirement for fuel oil to comply with maximum and minimum values such as these was a condition of the contract. And as I'm sure you all know, if a condition is breached, then the innocent party can terminate, or in this case, reject the commodity. An intermediate term, on the other hand, is the middle ground between a condition and a warranty in a contract. And the innocent party can only terminate a contract for breach of an intermediate term if the breach deprives them of substantially the whole benefit under the contract. And in this case, Galtrade argued that the term requiring the oil to comply with the specifications under the contract was a condition. And therefore, Galtrade said it was entitled to reject the goods because that term was breached. And BP agreed that they had breached that term because the sulfur content was too high. But BP argued that the relevant term was an intermediate term, not a condition, and therefore that its breach in supplying the non-compliant cargo was not serious enough to give rise to a right to reject. The judge agreed with BP and held that the relevant term was an intermediate term. And that is consistent with sort of the general approach of the English courts, which is and has been to classify terms as intermediate terms unless the term is specified as a condition, either by the contract or sometimes by statute. And in his reasoning, the judge pointed out that BP's standard terms did not expressly state that the requirement to comply with the spec was a condition, and didn't expressly state that the buyer could reject if the spec was not met. The judge also placed quite a lot of weight on the commercial circumstances, and I want to tell you about 2 points he made. Firstly, he said that if the buyer could reject the goods for any breach, however slight, then that would give the buyer significant commercial power, and correspondingly place significant commercial risk on the seller. And if that were the case, the parties should be expected to have made that clear in the contract. The second point he made in relation to the commercial circumstances was that the off-spec fuel oil was still marketable and could be blended with other oils and sold on, as is quite common in this industry. So it couldn't be said that any deviation from the specification would always cause substantial prejudice to the buyer. And again, that meant, he said, that the parties would not have expected a right to reject to exist without saying so in the contract. So what are the implications of that for drafting commodities contracts? Well, the key point really is that if parties to a contract intend any deviation from a contractual specification to give the buyer a right to reject, then the parties should make very clear in the contract that the term requiring compliance is a condition, and that any breach, however small it may be, will give rise to a right to reject. So moving on to the second limb of the issue, which is, did Galtrade have a right to reject the cargo for breach of the intermediate term? Now, Galtrade said that it did, because the breach deprived it of substantially the whole benefit of the contract because it didn't receive what it had contracted to buy. The judge disagreed with that and decided that Galtrade didn't have the right to reject because he said the oil supplied was not a wholly different product from what was contracted for, and it could be marketed at an appropriate price. And indeed, that is what happened to this fuel oil after the rejection. So he held that Galtrade could be adequately compensated for any reduction in the marketable price due to it being off-spec through an award of damages. And that conclusion had quite important consequences and meant that Galtrade was in breach of contract for wrongfully rejecting the non-compliant cargo. So in terms of the key points to bear in mind when a party is considering whether to reject a cargo that doesn't comply with a contract, firstly, it's very important for a party in that position to be clear whether there is a right to reject or not. And that's because if a buyer wrongfully rejects goods, it might be liable to the other party for losses suffered due to that wrongful rejection. And secondly, whether a right to reject arises is a question of fact and will depend on things like how different the product supplied is and whether it can still be marketed or used by the buyer. If the specification is only narrowly missed and the product supplied is essentially the same but perhaps of lower value, then it's likely that the buyer can't actually reject those off-spec goods. So before rejecting, a buyer should consider whether other contractual remedies such as damages or a price reduction would be a sufficient remedy. And it might be that the buyer should accept the goods, but then could sue for damages, which might include wasted expenditure in dealing with the non-compliant cargo, or perhaps loss of profits because that cargo is worth less. So that's everything I wanted to say about this case. I hope that provides a brief summary. And I think Elliott and I are now happy to answer any questions.
Thank you so much, both. There are two questions in the Q&A for Elliott. Elliott, I guess you may have seen them, but in case you haven't, I'll give you a moment to read them. And Clementine, somebody sent me a question directly for you, which is, do you expect to see changes, or would you expect to see changes to standard terms and conditions used in the industry as a result of the decision? feel free to answer, Clementine. I don't know if that came across.
I can go ahead, yeah. So I think potentially, definitely, I think we would definitely expect that parties that want to ensure that right to reject exists might now want to build that explicitly into the contract. But for obvious reasons that may not benefit the sellers of products such as fuel oil, particularly because fuel oil, as the judge actually said in this case, is sort of a naturally occurring product. And it might be that there are deviations from that spec. And if those deviations are very small, a seller may well not want to specify that right to reject would exist. So I think we might see some changes, but it's going to depend on sort of the bargaining between the buyer and the seller.
Thanks for that. Now, Elliott, you now have 3 questions. I'm very keen to move on to Anna and Adam. Why don't you give at least one of these, your favorite one of the 3, a quick answer if you can.
Well, I'm going to go with the first one. I'm not saying that's because it's my favorite, although it's not my unfavorite, but it's just it was the first one. So in your opinion, could the decision of the Court of Appeal in the Eternal Bliss serve as an incentive for the ship owners to negotiate higher demurrage rates? In theory, yes, because all of a sudden, well, not all of a sudden, I'll get to that. In theory, yes, because in theory, everything's now covered by demurrage. All kinds of losses, all kinds of risks are now covered by demurrage. So in theory, owners will want more money for that. I say in theory because I'm not quite sure it will have that effect. I'm not quite sure whether it will increase demurrage rates or whether there will be an effect on demurrage rates. I'm also not quite sure whether the parties or whether there will be a sudden redrafting of all these demurrage clauses. And I say that because, as I said, the Court of Appeal's decision really restores what was taken as the orthodoxy after the 1991 decision of Justice Potter in the Bond. And we had 30 years of Justice Potter's decision in the Bond. There wasn't, as far as I'm aware, any widespread changes made to demurrage clauses by individual parties or standard charter parties or industry bodies. So in the absence of that, and as the Court of Appeal observed, if the parties want to change it, they can, but they haven't. And they haven't in 30 years that took place since the Bond. And most of the contracts, the charter parties that we'll have these days, have probably been executed before Andrew Baker Jay's decision and after the Bond. So I'm not sure there will be much of an incentive for ship owners to negotiate higher demurrage rates or indeed to redraft their demurrage clauses. We've got a default rule now that sets it out pretty clearly. Maybe there'll be some bespoke clauses here and there, but by and large, I can't imagine much will change, but I could be wrong.
Well, that's very interesting. One area in which I've seen these kind of issues arising recently is vessels carrying coal that have been sitting from Australia, that have been sitting off China for a very long time. And one could imagine a scenario in which an unwary charterer accepted some kind of variation to the demurrage regime that normally applies and being stung in a way that they would never have anticipated in that kind of scenario. Thanks very much, Elliott. And thank you for all the people who've asked questions. There might be an opportunity maybe to follow up by email with Elliott. I'm keen to move on to Adam and Anna. Do keep your questions coming in for those whilst they're speaking. In fact, I can see there are more questions coming. So Elliott, I think your morning's going to be taken up answering questions, and there's one for you as well, Clementine. Maybe you can get into email correspondence on that. So without further ado, I'll hand over to Adam.
Good morning, everyone. It's my pleasure as the Essex Court Chambers member of this panel to speak about the Court of Appeal's recent decision in Shanghai Shipyard and Reignwood. This is a case which is important for anybody who's interested in guarantees and shipbuilding disputes. And it addresses 2 issues, which are as follows. First, the rather philosophical but very important question of what is my guarantee? Is it a guarantee or is it a performance bond? The second question is, if there's an arbitration between the 2 parties to the shipbuilding contract, does that provide a reason for me as guarantor not to pay out until I've seen the award? Now, the first of those two questions is one which many of you would have come across, certainly I have in practice. But the second question is possibly a new aspect for shipbuilding guarantees, which has not been focused on in any real detail before. So in my view, it's an interesting case, but it also, in my view, highlights some traps for the unwary, which I will touch upon in my slides, including some of the rather quick decisions that parties and their lawyers will have to now reach in relation to what their guarantees require at a very early stage of a dispute. So if I can turn to my next slide, we'll quickly outline the facts. Now, the detailed facts of this case were, of course, specific and somewhat unusual, but the key pattern follows what I would describe as the normal course of events of a shipbuilding dispute. So we start off with a shipbuilding contract. This one was on the 21st September to build an offshore drill ship. The price was $200 million and was to be paid in 3 installments. The first of 10 million, about the time of signature. The second, 20 million, about 6 months later. And then the big installment at the time of delivery. The contract was on the CMAC form, which is a Chinese Maritime Arbitration Commission form, which is growing in its use in the industry more widely as an alternative to the SAJ form. The buyer named in the contract was one of several investors in the project, but due to the structure of that particular investment, a special purpose vehicle was interposed as a new buyer under the contract. Now, the circumstances in which that happened, I won't detain you with, but it is of interest to note that this is quite a common thing in shipbuilding contracts for a new vessel to be delivered not to a big institutional ship management company, but to a special purpose vehicle holding one ship, known, of course, as either a one-ship company or, prior to delivery, a no-ship company, with no assets apart from the shipbuilding contract itself. Now, in due course, there was a notice of completion that the yard had completed the building and a demand for payment of the final instalment, which was unpaid. There was then a notice of default, which went unanswered, or indeed, it was answered to the dissatisfaction of the yard, and then a cancellation notice when the builder decided to cancel the contract. A few months later, there was a demand made under the guarantee, but crucially, there was no immediate arbitration. The arbitration was only commenced approximately 2 years later in 2019, and that's an important fact which the Court of Appeal referred to in their judgment. So, turning on to the next slide, the issues. There are 2 issues, both of them of construction. The first was the guarantee in question a demand guarantee, that is to say one payable irrespective of whatever the liabilities were under the shipbuilding contract and just payable on the demand itself, or a see to it guarantee, which required proof that the buyer under the shipbuilding contract was in fact liable to pay this large sum of money over to the shipyard. And the second issue was, whatever the position on the first issue, could the guarantor refuse to pay until the dispute between the buyer and the builder had been resolved by the arbitration commenced 2 years after the demand. Now, at first instance, Mr. Justice Knowles held that it was a see to it guarantee and that the obligations were indeed paused by an arbitration commenced after the date of the demand. The Court of Appeal disagreed on both issues, as we shall see. So let's turn to the key terms. The next slide, please. I won't read them all. They'll be available on the slides after the talk, but you will see that they contain some very usual terms which are found in shipbuilding guarantees. Clause 1 refers to an irrevocable, absolute, and unconditional guarantee with a primary obligor and not merely a surety for the final instalment. Clause 4 requires that if the owner fails punctually to pay the final instalment and commits a default for a period of more than 15 days, then upon receipt of a written demand, the guarantor shall immediately pay you the final instalment with interest without requesting you to take any further action, etc., against the owner. The next slide. Clause 4 went on that if there was a dispute between the owner and the builder as to whether or not there should be payment, and such dispute was submitted either by the builder or by the buyer to arbitration, we shall be entitled to withhold and defer payment until the arbitration award is published. And then finally, if the owner fails to award the award, then we will pay. Next slide, please. Clause 7 and Clause 11 are also fairly common. Clause 7 essentially said that any disputes relating to the shipbuilding contract won't affect our liability, including any illegality, invalidity, or unenforceability of the shipbuilding contract. And Clause 11 just refers to a no set-off or counterclaim clause. So having considered the key terms, let's turn to the first issue. Was it an on-demand guarantee or was it a see-to-it guarantee? Now, the court drew this key distinction in very clear terms. There are two types of instrument, one which is payable upon breach of the underlying contract, and one which is payable on an event, in this case a demand. Now, the court held that there were 7 key factors which suggested that this was a demand guarantee and not one which was payment on breach. And these are highlighted on the slide. The first was it was an absolute and unconditional obligation. The second was that there was language suggesting it was not merely a surety that the guarantor assumed a liability. The third was that it was payable upon receipt of a written demand. Although pausing there, a lot of guarantees require a demand to be made, and so one questions exactly how much weight one can place on that particular indication. The fourth suggested immediate payment as opposed to payment after a longer time. The fifth was that there was no disputes affecting this guarantee clause, but again, that's relatively standard language, and I wonder how much weight could really be placed on that. The sixth was that it would be payable in due course upon an arbitration award, if such an award was forthcoming. And then the seventh, interestingly, the court put some relevance on the fact that interest was limited only to 60 days, suggesting that everything was supposed to happen very quickly in 60 days, and that a longer period of interest, for example, whilst an arbitration was continuing, was not contemplated. Now, apart from being quite helpful with showing what would be the factors to look for in any guarantee, the court went out of its way to point out that it's very unhelpful to use presumptions when dealing with whether or not a guarantee is of one particular type or another. And this was somewhat surprising because there's actually quite a lot of authority referring to presumptions, such as whether it's a cross-border trade, whether it's a bank issuing the instrument, and so forth. And the court took quite a dim view of all that. And you can see in the paragraphs 39 to 49 of the judgment, the court goes through quite a lot of authority and tries to put some rationality to it. So it's quite an interesting decision for that reason as well. Next slide, please. Issue 2 was the guarantee caused by the arbitration? And then on this issue, the court dealt with it quite quickly. Language is key. The guarantee was payable immediately. And so this created what was known as an accrued right to payment. In other words, the guarantor had a demand received, and the buyer had an accrued right as at that time to have payment. There was no divestment of that accrued right because there was no arbitration. And so the guarantor had to pay. If the arbitration had been commenced before the demand, then what happens was the demand requirement is replaced with an award requirement. So not only do you need to demand, but you also need to provide an award. And then finally, the court said there's no inconsistency with the short 15-day window to commence arbitration as a contract required, because it's a form of security. And so parties are entitled, said the court, to enforce it quickly. It was only the arbitration which caused the dispute, caused the guarantee. So the fact that there was a dispute which pre-existed the arbitration was not material. Next slide, please. And so, in my view, this creates some traps for the unwary that people should bear in mind. First and foremost, what is meant by a valid demand? When a party is looking at terminating a shipbuilding contract, he'll have to immediately go to his guarantee and look about the terms and see exactly what is the requirements of a valid demand. That will be very important because it's likely in a short time frame in which you have to act, you need to make sure that every I is dotted and every T is crossed to avoid yourself falling foul of the rules. What about negotiating time? In this case, there was a clause which suggested there should be a process of amicable settlement before starting arbitration. But the court held that that was not a reason not to apply the language of the guarantee. And so protective arbitration proceedings should have and could have been issued before negotiating. That might be a surprising outcome for certain parties in the shipbuilding world. Is there a distinction between an immediate payment or payment within 30 days? The Court of Appeal suggested that there was. If there was an immediate payment, then there'd be an accrued right immediately. But if the payment was only required within 30 days of a demand, then there would be no accrued right until the demand period had elapsed of 30 days. So this is quite an important point. If your arbitration was started within that 30-day period, then it would pause the guarantee, said the Court of Appeal. But if your clause requires immediate payment, that option isn't open to you. Again, looking at the fine print would be very important. Finally, pay now and argue later, but at your own risk. The Court of Appeal was very influenced, in my view, by the fact that if the guarantor was found to have overpaid, then the person who'd received the overpayment would have to return it at some point in the future. But that effectively means that you're paying and arguing the reversal of the allocation of risk. Rather than the guarantor being entitled to hold on to his money until he receives the arbitration award, he'd have to pay it over and hope that whatever company he paid it to would still have it 2 years later to repay it if the arbitration went against them. That might be something which a guarantor might want to bear in mind when negotiating these types of agreements. And then finally, permission to appeal. Well, as with Elliott's case earlier, it's possible this case may go further to the Supreme Court, so this might be the last word. But if it does go further, then that again will create traps for the unwary if this reasoning is in any way modified. So points to be aware of in the future. Thank you. So that's everything I have to say. I'll be very delighted to answer any questions which may follow after the next talk, which I'm pleased to say is Anna's talk, and I will pass over to her now.
Thanks, Adam. Good morning to you all, also from me, from London to wherever you are. It's excellent to see so many attendees. Thanks so much for joining us. I'm conscious that you've already had to absorb a huge amount of information this morning, or wherever you are, evening, and I'll try to be concise. There's one more case we wanted to discuss this morning. It's the Tai Prize, not as hot off the press as the Eternal Bliss, but it is a Court of Appeal decision from this year. It was handed down in January, and like almost all of the others, it might go further up. I know that the Supreme Court has been petitioned, but no decision has yet been made. So again, watch this space. This may not be the final answer and the final word on this particular case. I understand that you will be sent links to the judgments later on if you want to read them in your own time. Now, why is this case important? Why do I think you should know about it if you don't already? Most of you, I'm assuming, will have worked with bills of lading and will have been involved in disputes involving bills of lading. So they're very important documents. And this case really is crucial in reaffirming an understanding of what is happening when such a bill of lading is handed over and what the meaning of certain statements on such a bill of lading are, specifically those descriptions of whether a cargo is in apparent good condition and order, and what that means and what the implications of that are. The main takeaway, if you only remember one thing from this talk, is that the court held that a tendering of a draft bill of lading stating that the cargo is in apparent good order and condition is no more than a request to the master to satisfy himself that the bill in these terms can be properly signed and it does not give rise to a right of indemnity. That is probably unsurprising to most of you because that was the common understanding and indeed was also derived from a long line of case law, but it was affirmed in this case, and that is quite important. When you think about the risk allocation, again, most contracts are fundamentally also about risk allocation, and that affirms the understanding that a handing of a draft bill of lading with these words is an invitation to check, and it's not a warranty, does not give rise to a right of indemnity. Now let's unpack that. My talk, roughly as the others, falls into 3 blocks. I'll briefly talk about the facts, then the findings, and then some further debate, and then we'll have hopefully some time for further questions. I think there are roughly 7 facts that you should be aware of and that this decision was based on. Firstly, and here we come full circle to the Eternal Bliss, this was a cargo of soybeans that was being shipped from Brazil to China. So lots of soybeans being shipped and issues arising from that. Now, secondly, the soybeans were not in actual good condition prior to shipping. And that was a finding of fact that was then carried on into the appeal, and that was accepted. There was already too much moisture and some heat damage. So there was damage preloading. And that's quite important to bear in mind. It's different from other cases you might have seen and be aware of where damage occurred during a delay or during shipment, but there was a finding that those soybeans were actually not in good order. Furthermore, it was also part of the factual matrix that the shippers could have easily ascertained that damage, could have seen it, but no finding was made that they did in fact actually know about that damage. And that's also quite important. So they could have known, but they didn't. Fourthly, for the master and the crew, it was found that it was not reasonably possible to ascertain the damage during loading. That's presumably because of the dust, of the manner of loading, but it was found that on reasonable inspection, the damage would not have been visible. And then in the usual manner, the shippers' charterers presented a draft bill of lading, which stated that the cargo was in apparent good order and condition. The master signed that bill, and then the cargo arrives in China in a damaged condition and was rejected. Very briefly, where in the dispute chain are we? There's always, or very often, a chain going on. Head owners were held liable to receivers in China. They then sought a contribution from disponent owners, or owners for simplicity. They agreed to pay under the interclub agreement. And then they sought to recover from the shippers, from the charterers. And that's where we're at. It's between the owners and the charterers. And this was an arbitration award and Section 69 appeal. And the first instance decision was given by Mr. Justice Pelling, and the main judgment, with whom the other 2 judges concurred, was given in the Court of Appeal by Lord Justice Males. So that's just, if you're interested to know where in the whole matrix this dispute takes place. And as I said, it might go up to the Supreme Court. And briefly, the Court of Appeal agreed with the first instance decision. And therefore, there's no big discrepancy between the findings, and I'll just move straight into the key findings, which broadly, I think, fall into 3 headings. The first finding was that the cargo was in apparent good order and condition. And that's quite important. It's interesting because it really highlights that difference between the actual condition of the cargo and the apparent condition of the cargo. And that's a distinction to be very aware of. And that is different from the finding in the arbitration award, which found that the cargo was not in such condition. And the Court of Appeal arrived at this finding and confirmed the finding at the first instance by looking at various cases and restating that apparent good order and condition of the cargo refers to the external condition as would be apparent on a reasonable examination so far as meets the eye. And then, as you've already heard, they were of the opinion, and they found, and they based their decision on the fact that what amounts to a reasonable examination depends on the actual circumstances, and in this situation, the actual circumstances were such that upon reasonable inspection, the damage would not have been visible. And therefore, that's different from other cases. One case that was discussed quite a bit was the Noga Marine, where the damage was reasonably ascertainable by the master. It was about rusty coils, and that would have been visible. So that's a difference here. And therefore the finding was that the cargo was shipped in apparent good order, and that was accurate, even if it wasn't in actual good order. The second really important finding, I've already told you, is what is the status of that statement on the draft bill of lading. And they found it is an invitation to check, it's an invitation for the master and the crew to make themselves reasonably sure that the statement is accurate, and it is not a warranty. It does not give rise to a right of an indemnity. Linked to that, there was some interesting discussion, and that is the third main takeaway from this case, about the Hague rules, or the Hague-Visby rules. And that's perhaps the second more general point that you can take away from this case, because the court, especially at first instance, but then also in the Court of Appeal, was quite clear that where the Hague rules do deal with a certain matter, where they're not a complete code, but where they do deal with a certain issue, such as bills of lading and descriptions contained on them, which is covered in Article 3, Rules 3 to 5, then the court will be very slow to imply additional terms or to imply warranties on top of that. So that's an important point of principle to take away as well. Now, I'm conscious of time. There's room for debate because some interesting things were said obiter in the Tai Prize that are interesting to think about and to take away, and will maybe be explored further in other cases. The possibility was left explicitly open by Lord Justice Mayles that the tendering of such a draft bill of lading, with the words shipped in apparent good order and condition, could amount to an implied representation about the knowledge of the shipper. And that was left consciously in there, and I would encourage you to read paragraph 57 if you're interested in that point. It shows that the knowledge of the shipper, the actual knowledge of the shipper, might be quite important. And why was that in there? That was in there because there was quite a lot of debate, especially towards the end of the judgment, you can see that, about whether this regime, this bill of lading being merely an invitation to check, might give rise to wrong incentives, might give rise to an incentive to misdescribe cargo. And owners were quite strong in their submissions in arguing that it would be unfair, surely, for charterers who know that there is a defect to tender such a bill of lading and to then shift the risk to owners in this way. And that is why I think that possibility was left open about a case in which charterers actually knows there's a defect and tender such a draft bill. So that's an interesting area to keep an eye on, and whether such a case would be decided differently. I thank you for your time, and I am happy to take any questions. And if you have any questions for Adam or myself, now is the time.
Adam, Anna, thank you so much for your presentations. Really excellent, very engaging, and helpful with their practical tips and pitfalls. I have received 3 messages directly. One is not a question, it's a statement from Francesca, who was due to wrap up at the end to say that something has exploded on a case of hers, and she's been whisked off to deal with that. The other 2 are actually questions for you and Adam and Anna both. Let's try to deal with them very quickly. I'm aware that others on the Zoom will also have to be whisked away at this time in the morning. There's a large number of people on here. One for you, Anna. Does this decision mean that there are new onerous due diligence requirements for the master and crew? That's a question sent to me directly.
I think the short answer to this is no. It's not a new situation. It's an affirmation of what I think the industry has understood to be the case for a long time. And while there is this duty on the master and the crew to make sure that they're happy with the bill of lading, I think it's important to remember that most of the time that goes well. and they are able to do that. Samples are being taken, visual inspections take place. So I don't think this is a new regime. It's rather an affirmation of what is going on, in a similar way to perhaps what Elliott said about the Eternal Bliss.
Great. And we have Francesca back. That's good news. Adam, a question that's also been sent to me directly. You touched on these presumptions, I recall, in one of your slides, but the question that's come in is, how did the court analyse those presumptions that have historically been used to determine whether or not a guarantee is a demand guarantee or a C to it guarantee? Could you perhaps expand a little bit on what you touched upon?
Absolutely, sure. So the court treaded what I can describe as a fine line here. In one part of the judgment, they criticised counsel for citing too many cases about what other guarantees had meant, which is a lesson for us all about appellate advocacy. But what the court also did was it took a view that shipbuilding is its own little thing. And so questions about what banks may or may not do in different contexts and presumptions which apply to them only carry the argument so far. And the Court of Appeal did that, even though of the 3 cases which were cited to it, 2 of them involved guarantees being provided by banks, and only one by a company which wasn't a bank. But drawing it together, the court seems to have said, we're going to focus on the words, and we're not going to focus so much on the presumptions, which, as I touched upon, is an interesting development in this area of law, because obviously commercial parties will be looking at this and reading their own guarantees and thinking, well, how do I tell what I have? And if the presumptions aren't worth very much, because shipbuilding is its own thing, and if you can't cite cases to the Court of Appeal based on old wordings, well, where does that leave us? It's probably a matter which will work itself through, but it is an interesting feature of this case, I think.
Very much so, and a growing trend across several areas, as you probably recall from our battle in the commercial court. What do other cases mean, even on exactly the same wording? And that, of course, produced 2 divergent judgments in Jiangsu Guoxin and Zhoushan. Anna, there is one other question for you that's coming. I can see you typing an answer. There are still a lot of people on here. I'm sure very interested to hear your answer if you want to take this question orally. It says, if the circumstances at the port, say COVID restrictions, very topical, are such that the master cannot exercise that reasonable visual examination, how can the master protect himself vis-a-vis innocent bill of lading holders in respect of the representations made in the bill? If you can give us a quick answer to that.
Yes, and I'd be happy for other panel members to weigh in on this. I think it would be quite important to record that fact and to make sure that there's a record of this being the case, and that only subject to and to see whether in these circumstances the process can go ahead. And if so, then it would be important to record that this was a situation and this was the extent of the examination that could take place. I would also think that in an assessment of what is reasonable in these circumstances, that would be taken into account. But it's for sure, as always, good to have a record of that and to have a paper trail and to make sure that everyone's happy with the situation.
Wonderful. Anna, Adam, Clementine, Elliott, massive thanks from me to you all. And I'll hand over to Francesca, who is no longer under arrest.
Thank you very much, Andrew. I'll be very brief. I'm conscious of the time, but I would like just to say thank you to, of course, Fulham Court, to Essex Court, to Owen for putting together such a mighty event, and of course to all the speakers for their time. We're conscious and we know how long it takes to prepare such events. So thank you very much, and we look forward to seeing you in our next YMP event on expert evidence, which will take place on the 9th of December.
Thanks so much. Have a good day, everybody. Bye-bye.
Bye-bye.
Have a good day.